I figured.
Yeah, I'm not here with any kind of a complaint of any description. I don't have any outstanding public records requests. There's no, I don't recall ever having any public records issues with you all in the past, at least that I can remember. That.
Oh, I apologize. The email, and maybe it was, no, it's actually from you, and it says, it's come to my attention that your agency has some open government issues of which I may not be aware. So I
Yes,
did want to
that
round
is
up
true,
everybody.
but not in the way of a complaint.
Oh, okay.
Yeah. So what I want to do is, without, I don't want to sound vain, I assume that you all, there's some context to my involvement with public records issues.
We have heard your name.
Yes, okay. In the past, I first got involved with public records issues back in 2008, so I'm coming up on 10 years. And a lot of my involvement, maybe not most of it, a lot of it has been, unfortunately, in the context of litigation. My intent starting out, I had no idea that I would be involved to the extent that I've become involved with it. First, I just genuinely wanted some records and had difficulty getting them, and then realized that things didn't always work the way they're supposed to. And so over the last 10 years, my intent has been to, one, raise public awareness about citizens' right to access records, and to try to get agencies to be more responsive to that. Back in 2008, when I first met Barbara Peterson at the First Amendment Foundation, she estimated that only about 40% of public records requests were responded to in compliance with public records law from public agencies.
And we're talking in Florida?
Just in Florida, yes, ma'am. That wasn't my experience. My experience is it was closer to about 60%, but I've measured it over the last 10 years, and it's gone from about 60% to well over 90%.
Good.
State contractors, 10 years ago, the compliance rate was about 2%, and now it's about 90%. So it's been an expensive, long, exhausting, sometimes not very pleasant process. And a lot of things have changed, including the statute, and it's become much more, I don't want to say difficult, but involved for an agency to get sued over a public records violation than it used to be. Primarily because records requests now have to be directed to the custodian of records. And if a requester doesn't do that, then not only are they not entitled to recover their attorney's fees, but the fees can be awarded against them even if the agency actually broke the law. It's a terrible law, it shouldn't have passed, but it's the law of the land. In spite of that, I have become aware of, and this is not picking on you guys, these are very, very common issues. I think that what's happened is, in spite of the fact that compliance has gone up very dramatically, and again, I don't recall ever having had any compliance issues with you all. In fact, you and I have exchanged emails. I don't remember what it was, but it was several years ago, and I think I sent you an email saying, "Hey, thank you. It was a very positive experience."
Yeah, I remember.
And there must be something in the water, because Alachua County has been a very similar experience. Mark Sexton is sort of almost the standard by which I measure other people as far as responding to public records requests. There's been so much focus on the potential liability of agencies with respect to how they respond to a public records request. I think that a lot of agencies have completely missed other potential liabilities that relate to public records. And my expectation is that whatever frustration or anxiety or whatever public officials have had over potential litigation from public records requests, I think will pale in comparison to some of these other issues. And so what I was doing, I've done a statewide survey. I started with counties, sheriffs, municipalities, school districts, I don't remember. There were about 800 agencies I looked at. And there were 4 things I looked at. These are real simple, quick, easy ways to kind of gauge whether somebody's getting it right or not getting it right. It's not dispositive. Doesn't mean they're always getting it right or always getting it wrong. But they're binary. Either it's there or it's not. And my experience has been that if an agency is getting some or most of these wrong, that may be an indicator that there are other issues. So I'm only here as a friend. I'm not here to hassle anybody or criticize. It's just, I noticed a few things. I want to bring them to your attention, and you all do with them what you want.
No, great. I was under the impression that you may have had or had a particular issue with the Alachua County Sheriff's Office. I want to have everyone that's involved. Linda Brown is our records custodian, and then of course our PIOs. That's explanatory from the standpoint of they're dealing with the issues almost
Sure.
every day, as Bureau Chief Brown and then Cindy Wigan. And so we're here because I wanted to hear what those concerns were. So I'm happy to hear that you're not here with a particular complaint. And
Yeah, I'm not an adversary,
Oh, good.
in any way. So I've actually brought some samples or some documents, and I would have brought more copies. I didn't think to do that. So very briefly, the four things that I looked at, and I'll leave this with you, so if you want to take notes, feel free. Of course, you have an audio recording of it. So 668, 6067 requires that any public agency that utilizes emails or maintains a website has to have a disclaimer on there, hey, email addresses are public record. If you don't want your email released in response to a public records request, don't send us email. So that's one of the things that I looked at. And it's really simple because I can go to an agency website and either it's there or it's not. I didn't see it on yours. If it's there, I missed it, but I looked pretty deliberately. That's not a big deal. I'm not aware of any liability. There's no private cause of action. It's not like you're going to get in trouble over it, but it's one of those things that the statute's really clear. It has to be there, and either it is or it isn't.
Okay.
So, again, that's one of those nice binary things. It's not my opinion. Either it's there or it's not there. The second one is the fairly news from last year, the custodial identification, which I mentioned a minute ago. Now, I noticed in your lobby you all have the sign. Congratulations, you're the first agency I visited with in months that actually has the sign.
Terrific.
Yeah, so nice job. I did notice on your website, it looks like there's been a recent change where that has been added to your website. When I first did my review back before the holidays, it wasn't there. I double checked it yesterday, the day before. It is there now. So again, great that it's there. And I'm not giving anybody legal advice. I'm not a lawyer. I'm not qualified or authorized to give legal advice. But just from my own experience with wrestling with public agencies over some of these issues, that kind of informs my perspective. I think what's significant about that one is that if the requester doesn't make the request properly now through the proper channels, then there are all these consequences. Their case gets thrown out and the fees are bilateral unless the agency doesn't disclose the custodial information. I haven't been to any of your other facilities, and I think the statute's unfortunately not very well written. It's unclear as to exactly what an agency would have to do to satisfy that. So, for example, it says it has to be prominently displayed in the primary administrative buildings, which arguably this is the primary administrative building for your agency. But I would think, and I say this from a customer service perspective, not from a legal perspective, that if it were me, I would suggest that any place that might reasonably be described as a lobby that's accessible to the public probably should have some sort of a sign that says the custodian of records is, or this is how you contact them. Because the statute doesn't actually require you to give the name of the custodian, you just have to give the contact information.
Right, because it may change.
Because that might change,
Right,
that's
right.
exactly, whereas in fact, I've mentioned to my wife, the way you all are doing makes a lot of sense because you have what is essentially a static email address, so even if their personnel changes, it doesn't really matter.
Yeah.
The third issue that I looked at was copyrights. So on your website, you all have a copyright. And again, I'm not trying to give you any legal advice, but as a point of reference, if you look at page 164 of the Sunshine Manual, it addresses the issue about agencies getting copyrights. And in Florida, unless there's a specific statutory authority given for seeking and maintaining a copyright, agencies just aren't authorized to do it. So for example, the University of Florida, they have lots and lots of copyrights because they're authorized to do that in connection with research that they do. But I couldn't find anything that gave any kind of authority for any public agency of any description to have a copyright for a website. So for example, if you developed, and these are the examples I'm giving you from the Sunshine Manual. So if an agency developed data management software, they could get a copyright for that. Of course, they still have to make it available, at actual cost of duplication, et cetera. But I don't think there's anything that would actually authorize you to have a copyright. So here's the potential problem with that. Just aside from generally wanting to comply with the law, I wouldn't make this argument. I've never made this argument, but I could imagine somebody making this argument. A copyright limits what I can and can't do with information. And if an agency asserts a copyright, then aren't they saying we're reserving our rights, we're going to limit what you can and can't do with this information? And I would think that somebody might argue that's restricting my access to records. Do with that what you want. Again, it's just one of those binary things. Either there's a copyright or there isn't, and there is one. And
So I'm just trying to understand, the copyright that you're referring to is for our website?
Yes, ma'am.
Not the name Alachua County Sheriff, Alachua County, Florida Sheriff's Office?
Right. My understanding of what you had on there was it's a copyright for the website.
Okay.
We can,
These are really, by the
Yeah,
way,
no, point well taken. I'm hearing what you're saying. I'm just trying to understand, because I haven't looked at our website in a while, and I'm not sure. To me, the copyright would be for our name not to be used.
well, it says copyright 1999 through 2013, Alachua County Sheriff's Office, all rights reserved worldwide. And again, not to be too persnickety about it, but I would even argue, wait a minute, there's really no such thing as a sheriff's office, right? I mean, in Florida, you have the sheriff of Alachua County, but if somebody sues the Alachua County Sheriff's Office, the case is going to get dismissed because there's no such thing as a
Right.
sheriff's office or
Yeah.
sheriff's department,
Yeah.
right? So, again, I don't want to sound like I'm trying to be overly critical. I'm really not trying to be. I'm trying to change my approach in dealing with agencies. Instead of me being the person who's trying to pick at them, I'm trying to give agencies a heads up of this is how somebody might try to pick at you.
Right, and I'm taking this as constructive.
Sure.
And what you're saying is
And I mean it that way,
potential
yeah. Thank you.
potential issues may arise out of it. We'll look at it
Sure.
because I don't think you expect an answer today, and I don't have an answer today because we just need to look at it
Sure.
and see. But so far, everything you've said has been very constructive, and points are well taken.
I thank you, and that's the way I intended it to be. All right, so the fourth thing, this one gets a little more involved, but I think it's helpful. So, Section 119.071 contains a lot of the exemptions to the public records law. That's not all of them. They're actually, I think, the last count I have was 1,129 exemptions total.
Really?
And they're spread all over the statutes. They're just buried.
Keep up with.
Right.
It's very hard to keep up with,
Yes.
right? It's almost impossible. You would think somebody would say, wait a minute, we need to codify this and put them all in one spot, but
Right.
they're not.
Right.
So,
I had no idea.
yeah, and there's no easy way to find them except to just plow through it and kind of catalog it. So anyway, a big part of what's in 119.071 is subsection 5, which addresses Social Security numbers. So Social Security numbers are confidential, they're exempt and confidential, and it restricts what agencies can and can't do with them. But one of the really important parts of that section is that it limits an agency's authority to even ask for a Social Security number. So a public official is prohibited from asking for a Social Security number, even soliciting a Social Security number in any way, unless they do two things first. One is they have to give a written statement explaining the statutory authority for collecting the Social Security number. And that written statement, too, has to include a description of what you're going to do with it. And the agency can only use those Social Security numbers for the purpose that's in the written statement. And this is a really, really common issue. So there are several components of that section of the statute which I think create potential concerns for agencies. One is, and I can't imagine a judge ever doing this, but at least in theory, at least what the statute says, there's a $500 fine for every violation, up to $500 fine. Secondly, making a false statement in an effort to collect a Social Security number is a third-degree felony. So if I say to you, you giving me your Social Security number is required, that's a false statement. Unless there's some specific statutory authority that says so, that's potentially a problem. The big one is the statute creates a private cause of action for any affected person. I see this happen all the time. It's just amazing to me how many times agencies are collecting Social Security numbers without giving the written disclosure as to why. Anyway, so I found that there are at least a couple of instances where I did not see, I did find, for example, on this preliminary application for your Explorer program, for example, it asks for a Social Security number, and there's nothing on there that says this is the authority for collecting it, and this is what we're going to do with it.
Okay.
There may have been another one. What I'm finding with this is that it's there are some forms like this one which are pretty easy to find. My experience tells me that if you poke around a little bit, there are lots more. So, for example, there's a sheriff's office here in Florida. If you want to visit an inmate, you have to fill out an application. That application asks for a Social Security number. So if you visit an inmate, you've given up a Social Security number, and not one time have they said, this is why we're doing it. So this is not just some little esoteric thing. It turns out there, I guess, 5 months ago, maybe 6 months ago now, notice was given to Manatee County School District of a pending class action lawsuit over this very issue about collecting Social Security numbers and how they're maintaining Social Security numbers. From a law firm whose name we would all recognize. My sense is that there's going to be more of this. Even if an agency is successful in arguing sovereign immunity and we limit attorney's fees and all that stuff, and there's no damages, we're still talking about 6 figures of legal fees before it's over with. And I wouldn't think it would be terribly difficult for somebody that really was motivated to find people who might want to participate in that class, because I'm guessing that not every person who's visited an inmate in a jail feels real positive about that particular jurisdiction. And I'm not saying that they shouldn't feel positive. I'm just saying that there are probably lots of people that have some sense of frustration, and I'd be happy to get my pound of flesh.
Right.
The other issue, of course, is what do you do with the Social Security number? So, for example, and again, I'm not giving you a legal opinion, maybe I missed it, but if I'm right, where this one has collected Social Security numbers without giving the written statement, those Social Security numbers can't be used for any purpose other than what's in the written statement. There was no written statement, so they can't be used. The problem is, what do you do with them? So, I don't know if you saw this, just recently in Hillsborough County, there was a homicide detective at the Tampa Police Department who just a couple months ago was sentenced to federal prison because he and his wife, who was a sergeant at TPD and a non-sworn co-conspirator, were mining TPD's records, collecting Social Security numbers and filing false tax returns. So there's real potential liability for somebody that, bad things can happen if Social Security numbers get misused, which is the whole point of the statute. But you can't destroy the record because it's a public record. Right? You can once the retention schedule's up, but you have these documents floating around that have Social Security numbers that somebody's not supposed to have in the first place. So anyway, it's just one of those kind of public records brain teasers, kind of what do you do with them? If you got them and you're not supposed to have them, what do you do with them?
Right.
Any questions so far?
No, I know several years ago something came up that caused us to look at the Social Security issue, and we did a pretty thorough agency-wide job of it. That surprises me. We still have a form out there. Correct that. But no, I follow what you're saying and see the potential of liability and just wrongdoing, and intrusion into people's private matters. So I understand.
Just as you all may already know this, I don't mean this to sound pedantic or condescending, but like with this one, some people aren't aware of this, if you go to your website and just at the end of the URL do a / space and then pick whatever keyword you want, it'll mine your website. So all I did was that and put in the word Social Security number, and boom, it pops up.
I wasn't aware of that.
Yeah, so it's a clever trick for if you want to really kind of dig in, because it won't show you anything that's password protected, but it will show you stuff that's not actually part of the directory in the website. So just as a
So say it one more time. It's /
your URL / space and whatever your keywords are, and you can do Boolean searches, and it's for doing what I do, it's a very useful tool.
I can see where
So
it would be.
you may find that helpful. So those are the issues that I wanted to bring to your attention. Now, my expectation is that with a little more examination, I would find more. I'm almost certain of it. And I would like to do that. I would like to work with you all to do that. My hope is to help you identify unidentified liabilities. I have a very high level of confidence that they exist. I would stop just short of certain. I don't want to have an adversarial relationship with any public agency. I would love to be a resource rather than an aggravation. I haven't switched sides. I'm still as committed to civil rights and transparency as I've ever been. I'm hoping that by taking a more collegial approach with agencies, that I can make that happen without the aggravation and expense that has been attended with all the public records litigation. So, for example, one of the issues that it frequently comes up would be like social media, which I know you guys have had some issues with in the past.
A few.
Yeah, I mean, I'm like I say, I'm not switching sides, but a lot of I'm moving a lot of my acquaintances are civil rights people now. I describe myself as a civil rights activist. So one of the things I would like to do is to be available to you and your agency as far as helping to contemplate how to maybe interact more effectively with activists. I give talks to both agencies and to activists, and I'm telling everybody the same thing. It's not like I'm telling one side one thing and telling the other side the other thing. As an activist, what I want is for you to overreact. If you don't overreact, there's no story.
Right. Some activists, not all. Some
Well,
activists.
I'm not saying that all activists embrace that.
Right.
I'm saying that when I talk to activists, that's what I'm telling them, is that if, for example, Jeff Gray, who I'm very good friends with, you know what I'm talking about.
Yeah.
Honor Your Oath, Jeff Gray, I figured everybody in the room would know. He's very well known for videotaping law enforcement. Sav Charidat, who you know Sav, right? When I talk to people like that, one of the things I try to explain to them, and those two guys in particular are actually very rational, reasonable people, and there are all stripes, right? Civil rights activists aren't monolithic any more than law enforcement is. You have all kinds. Like when Jeff Gray goes out to videotape law enforcement officers, if the law enforcement officers ignore him and just keep doing what they're doing, he gets bored and he moves on. If, on the other hand, a law enforcement officer storms up to him, grabs a camera and says, "Get that camera out of my face," it's going to end up on YouTube. I would like to be available to help with at least thinking about how agencies interact with those or respond to those situations. Any of this making any sense? Any questions?
No questions.
You know what my reaction would be is, have you approached the Florida Sheriff's Association from a training standpoint?
I haven't approached it directly. I've talked to a number of sheriffs, and I'm getting ready to say it, sheriff's offices, which don't really exist, but I've talked to their staffs. I had a very positive meeting with Gilchrist County and with Polk County, which is where I live.
Oh, you're in Grady Judge
I
territory.
am. Yes, ma'am.
Okay.
Yes, ma'am.
You walk in the midst of a hero to so many.
Yeah, it's one of those. I think of myself as the loyal opposition. I am a very vocal critic of Sheriff Jebb, but I have a really, really positive, warm, friendly relationship with his legal staff. And with his PIO,
Sure.
Scott Wilder, I get along really well with him. As far as, one of the issues that's come up, and I'm saying this as I'm reaching out to agencies. I understand why some agencies would be skittish about dealing with me. I get it. I think that I would like to say that my reputation is not deserved, whether it is or it isn't. I think I bring a fair amount of expertise to the table. I think there's no question in my mind that I'm finding things that agencies are missing, and that's not a criticism of the agencies. You guys have a lot of stuff to do.
Mm-hmm.
You have to be good at everything. I just do this. My depth of knowledge, I think, is extensive here, but outside of this is not. So it's easy for me to find problems.
Mm-hmm.
But whether that's fair or not, the fact is, I very consistently I'm finding shortcomings with agencies relating to public records issues, and again, not so much in how they're responding to public records requests anymore, but these other ancillary issues. Some agencies have been really positive, and have said, yes, we see what you're talking about, this sounds good, we'd like to contemplate, working with you. I've had some others who are like, no, we got this, we don't have any problems, which I find sort of really frustrating, because again, this isn't my opinion. It's either you're complying or you're not complying. The law is really clear. It's kind of like the 668 thing. Either the statement's on the website or it's not on the website. I would love to do training. I've been really fortunate over the last 3 or 4 years. I've done some training with the Levy County Sheriff, Gilchrist County Sheriff, Williston Police Department. There are about a dozen agencies. Really sweet people, very positive interactions.
Well, my sense of you, and again, knowing only of you from the standpoint of the emails and knowing that public records requests have been made, and as far as I know, we've been responsive and compliant. But my sense of you is that you're very genuine in your interest in this area, and I think that it speaks well of you from the standpoint of acknowledging that you don't have, you're all-knowing across the board, that this is your area that, for whatever reason, you have chosen, and you've got a pretty extensive knowledge base in that regard, and I think your intentions are good and purposeful. I'm not sure if what you're saying is being of help, is that as someone that we would hire to do this, or someone that is, like you're saying, of being available for training for others. That's why I mentioned the Florida Sheriff's Association, because that would give you an audience before, maybe not all the sheriffs, but the majority of them.
Sure.
I think at our conferences we have as many as 65, out of the 67 that are able to show up for the conference, and providing a training component makes your intention better known, because it sounds like there are some, and I think some of us in this room included, that are a bit skittish, not sure what your intentions are, and are you coming in to trick us or what. But from hearing what you're saying, what you pointed out, I see that you've got a broad base and I think a good intent of making sure that we provide the public what we should be providing the public. And I'm in between those who say, no, absolutely, we don't need it, or we're not doing anything wrong. And I'm in the middle of saying, I believe that I've got the staff here that can examine some of the points that you've made up in others, and do the job from the standpoint of making sure that we are as compliant and provide the customer service in that same regard. And so right now, I think we're good, but I do think many sheriffs, and me included, would be willing to hear more from a training standpoint and what you do, what your intent is and what you do have to offer.
Thank you, I appreciate that. Yes, what I'm proposing is that you all hire me as a consultant, and I'm doing this now with. I just started doing this as far as approaching agencies about doing a consultancy. So essentially what I'm proposing to do is, first, I would provide a very thorough review of the public records component of your agency as far as how you're responding to public records requests, what the policies and procedures are. Again, I'm not giving you any legal opinion. I'm doing this purely from a customer service. I've made thousands. I have no idea how many thousands of public records requests I've made, probably hundreds of thousands. I've experienced some really positive responses, including your agency. I've experienced some which were really not just bad, but horrific, scary. And I think that those kinds of things still happen. I don't think they happen here, but I would like to start with a very thorough review. That review would be followed up with a very detailed written report as to what I found. It would address not just these minor issues we've talked about, although the Social Security number thing's not entirely minor. There are other bigger issues. So for example, one of the things I would want to look at is 69081 parent 8A. So it's the sunshine and litigation statute. So if I go down to Walmart and a shopping cart injures me, Walmart is prohibited by law from demanding that I enter into a confidential settlement agreement. Can't do it. And the reason is we want the public to know if there's something that hurts people, right? The whole idea is if there's a public hazard, we want people to know about it so they can protect themselves. The second half of that statute addresses public agency specifically, and it's much broader. It doesn't simply limit or prohibit the entering into confidential settlement agreements where physical injuries are concerned. It prohibits confidential settlement agreements regarding any claim against a public agency. And what I have seen over and over and over again are settlement agreements, whether you're talking about workman's comp or other settlement agreements, where agency after agency after agency in Florida has entered into these confidential settlement agreements. And it's just boilerplate agreements, right? That if I had a conversation with two attorneys whose principal practice area is representing public agencies, and I have a very warm friendship with them. And I asked them about this because I found that there were two settlement agreements that they themselves had actually drafted on behalf of a municipality. And I asked them about this, and they're like, yeah, you're right, but that's just, it's stock. Well, the problem with that is that particular statute creates a private cause of action for any person in Florida. I don't have to be a party to the settlement agreement. I don't have to have any connection whatsoever to it. I can file suit and ask a court to invalidate the confidentiality provisions in a settlement agreement. Well, if there were somebody who wanted to watch the world burn, you talk about having a field day, because it's not like these things are just occasional occurrences. They're a really regular thing. So one of the things I would want to do is to look at settlement agreements, which are public record anyway, and see is there any confidentiality language in there, because I really fully expect that at some point somebody's going to start litigating that, just like the Social Security number issue. And that's the kind of stuff I'm wanting to help your agency and other agencies identify, because I think, as I said early on, there's so much focus on the liability of how somebody responds to a public records request. And my realization has been that, and again, I wasn't doing it to cause trouble, I was doing it because I really wanted people to make records available. But if somebody really wants to generate legal fees and somebody really wants to create heartburn for public agencies, that's nothing. It's this other stuff because it's happening on a mass scale.
And it may be overlooked, like some of the forms. Do you have a VITA or a proposal?
I do, yes ma'am. So I'm going to leave this with you. I'm going to leave you this. This is the cover letter, which basically covers what we've discussed today.
Okay.
And here, you can have these samples as well. My proposal includes, I would be available to do as much training as you want. I'm happy to do that in whatever fashion you want, whether it's for large or small groups of personnel. One of the ideas that's come up in talking to agencies is actually to, because I'll do them, if you want me to come up here 10 times, I'll do it, is to make some of those open or advertise them to the public. I think that the benefit to an agency is twofold. One is it communicates we are transparent and we want to comply with the law. And second, I think it may help to kind of create some parity between expectations. The kinds of people I imagine that would show up to a training like that are probably the kinds of people who make public records requests. And I get this a lot. I get CC'd on emails for public records requests that are going to some agency. I don't know any of the people. I don't have anything to do with the requester. Somehow they have got my name and they think that CCing me is going to make a difference. It doesn't. And I'm genuinely embarrassed sometimes by how ridiculous and outlandish their demands are. And I am very sympathetic to the agencies. So having a training where the public's welcome so that somebody can explain, not from an agency perspective, but from a civil rights perspective, this is what reasonable time means. It doesn't mean right this second. It means this is what how the courts have interpreted that. And then in addition to the training and the written report, my intent would be to give you a heads up as issues come up. So for example, in Williston, where I'm almost finished with their report, one of the things I was looking at is electronic communications. So one issue that comes up is the downstream distribution of emails. There's no way really to control that. So when you're dealing with confidential and exempt information, like the names or identities of the victims of sexual assaults, not only, it's not just exempt, it's confidential. Well, the problem is once you send an email with an attachment, you lose control over what happens to it. So anyway, I was looking at that issue and their email policy, and one of the things that I noticed was they explicitly state, and I think their motives were good, that all emails on city servers are public records and will be treated as such. Well, that simply isn't consistent with what State v. Clearwater, it's a Florida Supreme Court case where they said it's not where the record is, it's what the record is, right? The example the court used was if a public official brings a birthday card for their mom and they put it in their desk drawer, that doesn't become a public record. It's a double-edged sword. It also means that if I'm using my personal electronic device to send public business, it's still a public record. Well, the problem for Williston, I think, potentially is they've already said in their policy, we've received these as public records. Well, I think there's a pretty good argument that they're public records no matter what they say now. It's that kind of stuff that I want to, as I see that kind of thing, my intent is to let my clients know, look, there's a potential issue. I'm not saying you have it, but this is something to be aware of. Or like the Social Security number thing or the confidential settlement agreement says, I become aware of those things. I want to communicate to my clients. These are potential issues you might want to contemplate.
Right, okay. I'll be happy to look through this and have general counsel look at it and let us discuss what you've said today.
Okay.
And give, we'll just powwow and see where, but I would encourage you to contact Steve Casey, the director of FSA.
Okay.
It's too late to do anything for the winter conference. I don't know if there's time to get some training in for the summer conference, but they may be interested. Do you know our Sheriff's Association attorney, Wayne Evans?
I know the name.
Okay, great guy. He does really good training for us in ethics and in public records law as a regular course of business for us to stay up to it. Stay up on it because it is ever changing and very important.
Well, thank you again for your courtesy, and I really appreciate you all, everybody meeting. I know you guys are really busy. Any other questions, comments, or concerns I can try to answer?
None for me.
No, appreciate it.
Thank you so much. I
Thank you.
appreciate it.